Could I now introduce to you, please, Sophie Hill? Sophie is a leading junior in family law. She has a particular emphasis on HNW, and Sophie's going to tell me what HNW stands for when she starts talking, and international financial matters. But she regularly represents parties in complex private law, children disputes as well. She co-founded the Adoption Forum. So, Sophie, we are very much in your debt and also in Sarah's debt. And you've done that drawing on your previous experience of public law proceedings, where the question of post-adoption contact was often a key issue and continues to be a really live issue and a developing issue within the case law that emanates from the High Court and the Court of Appeal. So, Sophie, I wonder if we could begin with asking for you to give us an overview of developments since November 2025, that auspicious day, I think on the 18th of November, when the Adoption Forum met in your chambers.
Yes, and you'll recall it was packed, and it's so good to see so many people here today. So we're really grateful to you for your time. There was a follow-up meeting after the conference on the 19th of November for the lived experience group. And the feedback from that was a desire to meet again. So we have proposed that the lived experience group will have another meeting in November. And we, since the conference in November, have commissioned a piece of research which Dr. Julie Young has completed on our behalf. And there is significant overlap between the contact issues post-adoption and in the context of special guardianship orders. And so that's been her focus, and you'll hear from her later. We are very honoured that she did this piece of work for us. It's clear that the issues are readily extendable to situations where any child is not in their family of origin. And we believe that with SGOs, special guardianship orders, more formal research and more thorough understanding of birth families, including addressing the complexity around siblings and half-siblings who may be adopted, is key. Now, the work we have sent out to everybody, the written documents, there are 3 of them, and they are very much interlinked. I have been focusing on the legal side, but drawn on what we experienced in November in terms of the feedback and the further meetings. Now, in respect of why we're doing it this way, we, Sarah and I particularly, asked ourselves whether we could design a document to give effect to the public law working group recommendations. And as lawyers, we work with guidance. So we have come up, Stephen, with a proposal. It is only a draft, but it is a draft aimed to implementing the recommendations of the public law working group and reflecting the information that we've received from the stakeholders at the conference. So it's a consultation document, not the finished article, and we have made it look a bit like a practice direction because we wanted to see how a proposed formalised approach could be introduced into practice. And that, we hope, is the next phase for the Adoption Forum, where we will be seeking external advice and advice from the Adoption Forum, which you are now all members, from other groups and bodies such as the ALC. That's the update, Stephen.
Thank you. I think it's incredibly helpful, actually, that it is in the form of as if it were a practice direction, because that then allows us to see, those of a legal mind at least, to see exactly how it fits in with existing practice. So thank you very much. And it must have taken a considerable amount of work to create it. But I think also you're now going to benefit us with an account of the legal framework in which these discussions are now taking place. So once again, Sophie, over to you. Thank you.
I'm aware that we are a diverse group and we have different knowledge and experience of the legal framework, so please do bear with me. But we do have a statutory framework that we have to operate within. And that, although I will tell you about the updating case law, has not changed. So the legal framework comes from the Adoption and Children Act 2002. And there are three key clauses, I would suggest. The Section 34 duties of local authorities to facilitate reasonable contact under the Children Act. Section 26, contact during placement pre-adoption, and Section 51A, post-adoption contact orders. We, of course, always have to bear in mind the paramountcy principle, which remains the child's lifelong welfare under Section 1. And we come to this against a traditional approach whereby adoption was treated as a clean break. And now I would suggest that the case law is showing us that we can move away from the clean break, and we have a progressive, although slow, development of the law. In the past, direct contact orders were exceptional, and practice defaulted to letterbox contact, with the result that contact provisions, especially under Section 26, were underused and marginalised. But the Public Law Working Group that concluded its recommendations in 2024, chaired by Mrs. Justice Judd, marked the key turning point in thinking from adoption meaning severance to relational permanence, which requires a recognition of identity needs, lifelong family connections, and the importance of sibling relationships. And you may have seen either in the news or in your professional industry press that, for example, Josh McAllister, the MP, has commissioned research which has then led to a suggested amendment to the new bill in respect of sibling relationships. The key Public Law Working Group recommendations are that contact must be actively considered in every case. Section 26 can set the template for future relationships, and this issue requires a structured welfare-based analysis, not assumptions. We have the case of Re-B, in which the President opined that the starting point was that the imposition on prospective adopters of orders for contact with which they are not in agreement is extremely and remains extremely unusual. So that was the starting point for us. Following Re-B, the decision as to whether to make a Section 26 order is a pure welfare issue to be assessed on a case-by-case basis. But in practice, the making of those orders has been an extreme rarity, with little to no thought often being given to the issue of direct face-to-face contact after the making of a placement order by professionals, practitioners and judges, other than a reductive plan to letterbox contact. However, in Re-S, the Court of Appeal in 2025 gave guidance. Lord Justice Baker had previously had the opportunity to highlight the renewed discussion about what he called open adoption, and indirectly consider the point in September 2024 in a case called Re-R and C. That was a decision initially not to make placement orders and was an appeal against that, but it was not a direct opportunity to consider Section 26 itself. His Lordship commented upon the lack of cases evidencing a sea change in thinking regarding post-adoption contact. So Re-S was a turning point in which the care plan had originally stipulated that there should be direct face-to-face inter-sibling contact twice per annum once an adoptive match had been found. And whilst the professionals and parents in the case agreed that a lack of sibling contact would be a significant loss to both children, and that every effort should be made to promote direct contact between the children in accordance with the care plan, it was also common ground to the parents' credit that S's need for adoptive placement was his primary need. Re-S emphasises that not dissimilar to a Re-B-S analysis, there is no shortcut to the determination of whether or not there is a need for a Section 26 order. The court must consider Section 26 in every case through the prism of Section 1(4) and conduct a full and thorough holistic welfare analysis of the respective advantages and disadvantages of post-adoptive contact and the need or not to enshrine that in a Section 26 order. In Re-S, part of the reason for why the Court of Appeal, however, concluded that the lower court was not wrong to decline to make a Section 26 order was due to the extensive and thorough welfare analyses and the emphasis on post-adoptive contact already contained within the professional evidence before the lower court. So the appellate and the lower court were satisfied that the advantages and the disadvantages had already been thoroughly considered by the professional parties. And all of this boils down to how we have sought to enshrine these considerations within the best practice guide, so that there are no steps missed, no stone unturned, and that the court is given the fullest picture in the children's best interests of what will meet their individual identity and welfare needs in the future. In respect of the no order principle, it's still the case, and Ries makes plain, that the no order principle remains central. And so we are still at an early stage of this progression. And whilst we are enlightened and heartened by the decisions of Ries and by the analysis in the Public Law Working Group, the issue for us going forwards, and as considered in the case of Ries C, D, E, and F, is that in respect of the depth of analysis, it has been lacking in the past, and we hope that this is something that we can help to remedy in the future.
Thank you very much indeed. And isn't it interesting how the case law is still gradually developing, notwithstanding that adoption has been a feature of our law now, I think, for over 100 years, but also that the recent cases are focusing on sibling relationships. There does feel as though there's a long way to go in development of law relating to parental contact post-adoption, and it'll be interesting to hear people's views about how that is developing. But thank you very much indeed, Sophie, for that succinct summary.